Good day, listeners. You've tuned in to More Than a Funeral, Voices of the Red River Valley, powered by Corsmo Funeral and Cremation Service right here in Moorhead, Minnesota. My name is Tom, and I'm going to be your host today. And whether you are listening on your computer, maybe your phone, car, any other kind of device, and possibly even your tractor or combine, we welcome you here to today's episode. We all know there are so many funeral-related podcasts of interest dealing with so many various issues, but our focus is going to be on the personal aspect of relationships and the multitude of interesting people and organizations that like to call the Red River Valley their home. And on occasion, we might push the edge a little bit, discuss some of those controversial issues. We all know what we're talking about. Red Jell-O. Is it appropriate to serve at church potlucks anymore, or is it a taboo subject? And there's so many other things such as hot dish, casserole. What's the difference between the two anyway? So, we invite you to sit back for a few minutes, grab yourself a blistering hot cup of Lutheran Church coffee, and enjoy the conversation. We are glad you stopped by to listen. Good afternoon, listeners. You have tuned in to More Than a Funeral, Voices of the Red River Valley, powered by Corsmo Funeral and Cremation Service right here in Moorhead, Minnesota. You are tuned into episode number 12, and I'm really kind of excited to have our guest today, a gentleman by the name of Ken Norman. Ken is a very common name in the Fargo-Moorhead area, with an attorney here with his own law office. Ken has spoke to many of our conferences that we've had, and he's helped many, many people with their financial and pre-planning, estate planning. So we're going to get right into it. Also today will be Sean Nygaard, the owner and manager and co-worker of mine here at Corsmo. He is our co-host today, and he's going to ask some great questions as well, too. But Ken, just so that we know that we've got some credibility here, tell us just briefly about yourself. We know you're from the Valley, and you went down south to school, and some reason you came back.
Well, I don't know how much credibility I can lend to that, but yes, I'm from the Red River Valley. I grew up in East Grand Forks, graduated from high school up there, went to Assumption College in Richardson, North Dakota for a few years, got my AA degree out there. Then went down to Omaha, Nebraska, and attended Creighton University for a couple of years, got my bachelor's. And from there I moved on to the University of North Dakota School of Law and got my JD degree.
And is that then when you came to Moorhead?
I came to Moorhead in 1974, which is when I graduated, so that dates me.
Okay.
And then I started working as a trust officer at the then Merchants National Bank and Trust Company in downtown Fargo, and worked there for a few years before going into private practice.
Okay. We know, of course, we've known you for many, many years, but you also have a rich history, if you want to call it that, in the funeral business. When you were in Omaha, you did a little bit of night work down in Omaha. So tell us a little bit about that, too.
Well, as a student in Omaha going to a Jesuit school, in order to live off campus, you had to have a job that took you off campus. So
Okay.
Three of us applied for a job at a local funeral director, with a local funeral director, Gentlemen's Mortuaries. And I lived off campus in an old converted mansion in downtown Omaha, and worked for them for a few years while I was a student in Omaha.
Okay. So it didn't really directly impact your law practice, but you knew about funeral service, obviously.
Yeah, I did. I've known about the funeral service for many, many years. My great-grandfather started a funeral home in North Dakota up in Grand Forks, and I have been closely associated with people in that industry for a long time.
Well, locally, you're active in the community. Are you still president of the Public Service Commission?
No, I served on the Public Service Commission, which is the local utility for water and electric services, for about 30 years.
Okay.
And there comes a point in time when even I, thinking how brilliant I am, have to step aside and let other young people come in and put their mark on the utility.
Right. Makes sense. Well, Ken, like I said, we'll be one of a number of speakers that Corsmo is hosting for another seminar going to be October 7 at the Courtyard by Marriott, and we'll give some information on that later. We'll also post some links and some information on the notes too. But we're going to have a representative there, a couple of representatives from the local Veterans Service Office of Clay County, And again, we just welcome anybody to come to that. But we got Ken in here to kind of give us a little teaser, a little bit of taste of what we're going to be talking about. So we're just going to jump right into it, and I'm just going to ask a really very basic question. Sean is going to probably have a little bit more elaborate questions from a business standpoint, but I just know from personal experience when my mom was had leukemia, and she was we were looking at she was receiving treatment in Minot, and we could see the money going out a little bit faster, a lot faster than it was coming in. So we could see, kind of looking at her assets, about how far down the road she would have before she went on assistance of some type. She passed away prior to that, so that kind of remedied itself. But for somebody, let's just say mom had a nice estate or assets, so I'll just say 500,000, which is not too difficult to do these days. But we, as wise sons, could see that it's going to be gone before she passes away, and I really could use my pickup's getting a little old, and that we were thinking about putting that addition onto the house too. So would there be anything really wrong? We anticipate mom, from what the doctors say, is going to maybe hang in there 6 months to a year, depending upon treatment. But boy, if I get that money out first and I get that pickup, and we're going to do it in cash, of course, but how many red flags are you seeing here so far?
Well, if you're going to roll dice, I would suggest that you get on to Vegas and do it. Number one, if you take that money from Grandma, she may render herself to be in a situation where she would not be able to get medical assistance, which in Minnesota is a term for Medicaid, the federally funded program for long-term care. And when you go to make that application, when she can no longer care for herself and her assets are dwindling, one of the questions on the application form is, have you made a gift within the preceding 60 months? Mm-hmm. And if you've done so, that becomes a disqualifying transfer, and for which she will be penalized. And so with an average cost of nursing care at around $12,000 per month in Minnesota, it doesn't take long to chew up that $50,000 you were talking about, and she would be disqualified for a little over 4 months just because of your new pickup.
Right. And this nice new addition we want to put on the house, she can live with us, but that probably won't fly too terribly far. So in the funeral business, we do help families also protect their assets through setting up pre-planned contracts. And we have most people are familiar with the title of being an irrevocable contract, meaning it's protected funds. So we're grateful that by law we can help families set monies aside legitimately, not excessively, to pre-plan for their funeral. And it's nice because they don't have to make the decisions at that time. They can just set the funds aside, and then, of course, the final decisions will be made when they pass away. They won't have to worry about that. But I know from personal experience, it's tremendous peace of mind knowing that the funds are set aside. And if my kids choose to blow it, well, that's up to them. But at least my wishes have been heard.
Well, and one of the nice things about doing the prepaid funeral service is that when the time comes and the funeral director is in charge of your final disposition, as they say, you don't have to look at the members of the family and say, okay, everybody, it's time to pony up some cash.
That's right.
That you've used your money to, in effect, pay for your own services. Mm-hmm. And a lot of people like that.
Yeah, it's a tremendous gift, really. And you're right. At the end of the arrangements, we don't have to pass the hat, so to speak.
Well, and passing the hat has its dangers because everybody in a family has different financial situations, right. And some people may not be able to afford that. And that can cause for other stresses in the family as well.
Right on. Well, again, I'm just going to step aside here a little bit. I'm going to turn things over to Sean Nygaard, and he's got some good questions for Ken. And a little while, we'll give a little bit more footnotes on the seminars that we have coming up. So we'll see how Sean does.
So it's just you and I against the world at this stage?
It sounds like it.
Yeah.
Well, Ken, thanks for being here with us today. Tom, thanks for hosting this. I know folks are getting valuable information from all of this, and as Tom said, my name is Sean Nygaard, and I'm one of Tom's coworkers here at Corsmo, and we get the opportunity to sit with a lot of families during some of their darkest times, and a lot of the same questions come up, and we know, Tom and I know enough to over the years to be dangerous and kind of point the family in the right direction. But there's a lot of times where we sit down and we tell them that is an attorney question.
Right.
We can't elaborate too much on that. And one time, a smart financial guy told me there's three things that we need to have together when you're looking at end of life care or just life in general. And one of them was, out of the three, was a financial power of attorney. Second one was a will. And the third one, he said, was healthcare directive. Mm-hmm. And so my question to Ken would be, out of those three things, do you think that that is a smart thing for folks to have in place as they're navigating life?
Absolutely. Let's start with the financial power of attorney. Number one, you don't know what circumstances are going to put you in a hospital setting, or you could have a stroke and be unable to take care of your financial affairs. There should be somebody that you name, somebody that you trust, somebody that will not take advantage of the situation, who you can grant that kind of authority to, so they can take whatever action is necessary to safeguard your interests and properly take care of your financial affairs during your lifetime. And it's important that the power of attorney be considered as a durable power. And by durable, I mean we want that to continue during periods of disability, specifically during periods of disability. And for purposes of flexibility, I would suggest that we name more than one person and indicate that they can act independently of one another. The same holds true for the healthcare directive. It's important that you establish, in your own words, what you want to happen in a medical setting so that other people can take the actions that are necessary for you to be taken care of appropriately. And without that, you would need a guardianship, which is a court proceeding, in order to have somebody that can make those arrangements for you. And in Minnesota, at least, if you didn't have the financial power of attorney, you'd need a conservatorship. Now, you asked about a will. A will's a great idea. It's not always necessary. It depends upon the assets that we have and whether or not there are probate assets. And by probate assets, I mean assets in the decedent's name alone, particularly real estate. So there should be a careful examination of what assets the individual holds to determine whether or not a will is even necessary under the circumstances. And I don't know if that answers your question or not.
Yeah, it's kind of a lot of loaded stuff in there that we're going to kind of take apart here and digest so everybody that's listening can understand a little bit. First part of that was you talked about the durable power of attorney. When a family goes in and they say, you know what, my mom and dad are ailing, the rest of my siblings want me to be the power of attorney, is it at that time that individual says, Ken Norman told me to ask about durable power of attorney? What's the differences between the two?
Historically, a power of attorney terminates on three different occasions. They all terminate when we die.
Yep.
They all terminate when we revoke them. Yep. They can also terminate if we become disabled. And so a durable power of attorney just goes on to state that I want this power of attorney to be effective even during periods of my disability. That's the durable factor.
Okay. And, healthcare directives, I think a lot of the folks out there, they always say, oh, I got to get that done because the doctor recommended that I do that at my age. We've been told in the funeral business that the healthcare directive is a very powerful instrument. One being that, for instance, I could have my healthcare directive. I have a wife, Sarah, and I could have my healthcare directive listing Tom Pence to handle my body if something were to happen to me, and that would supersede my wife. Is that true?
Yes.
Wow.
In theory, at least. But
you ready for that, Tom?
I don't think Tom wants to handle your body, but that's a different discussion. And the thing is that whether it's a healthcare directive or a financial power of attorney, what we are doing is sending a message to those people who will make decisions for us.
Right.
And the healthcare directive, if properly drawn, can also indicate whether you want to die in a nursing home, whether you want to die in a hospital, whether you want to have certain procedures, which I caution against, and also say whether or not you want this individual or other individuals to make those decisions for you. And there should be some care when putting these documents together.
Yeah,
I, for
absolutely.
example, had a serious healthcare scare about 7 years ago, and I would not have wanted to say, well, don't do this, don't do that, because I don't know what's going to put me in that hospital bed, and I don't know what procedure my surgeon is going to require. And so from that standpoint, I don't want to say in advance, don't do this. Oftentimes you also hear people saying, well, I've got a DNR. Do not resuscitate. To a first responder, those are also magic letters, because if you have a DNR, they won't do anything. I had a client several years ago who had a slight heart attack. First responders are there, daughter was there. They looked at the refrigerator. The refrigerator had a cute little trivet that she got at a seminar that said DNR. The first responder said, we're not going to do anything. She's got a DNR, which time the daughter says, grabbed it off the refrigerator and says, I don't know what you're talking about. So they took her to the hospital and she was just fine, thank you.
Wow.
So you've got to be careful when you make these decisions. You do not know what's going to put you there. So don't make a decision in advance that is going to mess up the course of treatment.
You know, when folks get that healthcare directive done, should they see an attorney for that, or should they Colleen here in our office here at Corsmo's, she is phenomenal. She has a social work background. She's a funeral director. We've had a lot of families that have come in and set up their healthcare directive, and she's also a notary, and she notarizes that.
I didn't know she was such good character that she knew all those things.
Yeah, wow, I don't mean to.
And you can tell Colleen I said that.
So if families do get this healthcare directive done, is it important to notarize it?
Yes.
Okay.
Well, the Minnesota format requires either a notarization or two witnesses, either or.
Okay.
And so from that standpoint, it should be properly executed, because otherwise you don't know whether this is what the person requested.
Right. Well, and this answers a lot of the questions. So, I mean, having a durable financial power of attorney is one, and your healthcare directive, very powerful instrument in Minnesota and North Dakota, having that put together, listing the person that you want to handle your medical decisions, but also if things don't go well and you end up here at Corsmo's, having that same person being able to make those decisions. You know, another thing that we often hear about is the word probate. And we as funeral directors, we know what triggers a probate. But for everybody that's listening, can you explain to the listeners what exactly triggers a probate, what is a probate, and how can that be handled?
Well, let me start with the last question. A probate is simply a court-directed proceeding here in the district court that handles the assets of a decedent. And probate assets are those assets that were in the decedent's name alone at the time of death. In the decedent's name alone, that's the test. The other basket of property would be non-probate assets, and those are things that pass automatically to the people involved with some administrative steps without having to go through the probate process. So when you sit down to do estate planning, one of the first things that you should do is make sure what are probate assets and what are non-probate assets. And of course, here in Minnesota and North Dakota, what can mess up everything would be ownership of real estate, because real estate is the most finicky type of assets that you can work with in terms of transferring it from one person to the next, or from a decedent to the decedent's beneficiaries.
Interesting. You know, I always hear that the one thing that triggers probate almost automatically is real estate. But if they got that properly titled, what you're saying is if they have that titled to what's going to happen to the real estate after the person's death, you're saying that can avoid probate.
That can avoid a probate, but here again, you've got to be careful, you know. And so let me give you a couple examples. My wife and I own our home here in Moorhead as joint tenants, and that's magic language. That language indicates that we are joint tenants in the property. It's a non-probate way of holding title to property. If I die, my wife files a very simple affidavit and a death certificate, and the property is hers. Another type of non-probate ownership of real estate is something called transfer on death deed. Minnesota and North Dakota both recognize these. They're a wonderful tool. Essentially, my wife and I would make a deed. It says we are giving this piece of real estate, whether it's our home or our lake property or whatever it might be, to our children, effective upon the date of the death of the last of us. So for my wife and I, that means whichever one of us died last, that transfer then occur and take place.
What is that called again?
Transfer on death deed.
Transfer on death deed.
And the good thing about that, if I put my children's names on the title to my real estate and I wanted to sell it, in our great state, that means that not only do my children have to sign on the dotted line when I want a mortgage to put a new roof on the house, or if I want to sell it, so do their spouses. Because if you own real estate and attempt to transfer it as a married party in Minnesota, both spouses must sign. With a transfer on death deed, that's not the case because it doesn't really take effect until that triggering event, which I mentioned in this case would be upon the death of the last of the two of us.
So basically, if somebody has titles on their home, like for instance, I'll take for my home for instance. When we did the title work on my home, they listed my wife and I as the owners of the home. I don't remember seeing anything about joint tenants in common or anything like that. Is it an automatic for folks that are out there? They're married and
There's no automatic in the
there you
real
go.
estate world. Keep
So-
that in mind. The only automatic is in a car. And so from that standpoint, no, if it just has the two of you named, you're like a partner. Your partnership ownership. It's called tenancy in common. Each of you would own an undivided 1/2 interest in that property. Going back to my test a few seconds ago, probate property is everything in the decedent's name alone at the time of death. So if you own it as a tenancy in common, your 1/2 interest is a probate asset and would require a probate in order to properly transfer that onto whomever you want it to go to.
interesting.
So there are traps.
Yeah. So what would you recommend for those that are listening out there that are married couple? I got a couple more questions here that I'll ask that deal with married couples and so forth. But as a married couple, you bought your home when you were in your early 20s. You've lived there. You've raised your kids there. And now comes the time where it's like, okay, now we got to start thinking about what we need to do with the house. So I'm going to give an example. Family today, you just retired. The house is paid for. You've raised your kids. They are adults now. You got some retirement investments. What would you recommend to this family on their next steps, that couple?
In what regard?
What-
Narrow
what-
that question for me,
Sure.
Sean.
What would you recommend for them as they start to plan for their golden years of retirement? And they got their house paid for. They got a couple kids they're out of the house. They got their retirement. They're living within their means, and they just want to leave a legacy for their kids.
Okay. Well, the first thing I would suggest is that they sit down and list all of their assets. And in doing so, how those assets are held and whether or not they have beneficiaries for like life insurance policies, transfer on death accounts, payable on death accounts, all those types of things. And also sit down and figure out what their objectives are. Now, these two people may have lived together for 40, 50 years. They still may not share the same objectives when it comes to that legacy, let me tell you. And so from that standpoint, in my practice at least, I'm assuming that most estate planning lawyers do this, I have a checklist. And I give that to my clients and say, here, before you come in to see me, organize your thoughts, which will save you some money, undoubtedly. But at the same time, that forces you to really take a hard look at what you want to accomplish and what you have for assets. And in terms of moving forward, as long as they've got their investments and they've got the money coming in and they're comfortable, I would suggest that they go sit on a beach and spend every last dime.
Well, we often get families that in casual talk, as they're setting up their pre-plan with Tom, they'll often ask about trusts.
Yep.
And I know that there's different types of trusts, and maybe we don't have all the time today to talk about them, but can you explain some of the differences in trusts?
Well, a lot of times people are talking about trust, they mean revocable trusts. This goes back to my earlier comments with Tom. Normally, we set up a trust for somebody, and think of a trust as being something like an account. And that account says, this is what I want to happen during my lifetime. During my lifetime, I want the income off this trust. I normally would set up the trust in such a fashion that I would be my own trustee. You can also use independent trust companies or third parties to serve in that capacity. But the trust would say, this is what I want to happen during my lifetime. And then when I die, this is where I want my assets to go. And if you properly fund the trust, that is, if you properly transfer your assets into that trust, it becomes a non-probate vehicle.
Nice.
And normally that's because people don't always transfer all their assets in a timely fashion, and they leave some things behind. We normally have a very simple will. It's called a pour-over will that says, if I've forgotten to put something into my trust, pour it into the trust. But sometimes because of real estate holdings or other things, they fail to do that, and so they've not properly funded it. But that would be a non-probate trust. And keep in mind also that in some instances, those trusts are created so as to provide flexibility for estate tax planning purposes as well.
So is a living trust similar to a revocable?
Most living trusts are in fact a revocable trust.
Okay.
A living trust just indicates the document is written to take effect during somebody's lifetime as opposed to being created under somebody's will. That makes it a testamentary trust.
How much does a probate cost today?
Well, that's an interesting question. Not that I want to evade it, but here, most lawyers charge on an hourly rate basis for handling probates. It can be anywhere from $200 to $600 an hour, depending upon who you go to and how complicated it is. So it becomes a function of how much time has to be spent, and that time has to be justified under state statutes. Lawyers are not entitled to simply take a percentage of the estate because somebody tripped through their door. They have to account for the time that they spend. And so all I can say is I've had large estates in the past that are very simple and go off like clockwork and there's not a problem, and the fees aren't that high. I've also had very small estates that have more complications. Just as in your business, I'm assuming you had some funerals that weren't quite as easy as others.
Yeah, that's correct. Well, and you know, one of the things too that just came to mind, we recently had an individual who had a lot of cash in the bank, didn't have anybody on the account other than themselves. They had kids, and is there a certain cash monetary value that would trigger a probate?
If that was sitting in Dad's name alone on the day he died, and there's no other assets, so to speak, in Minnesota, if the value of the probate estate, and go back to probate is everything his name alone. If the value of the probate estate is less than $75,000, you can go into the bank and collect that by affidavit. There's a procedure that is called a collection by affidavit that allows you to do that. Take a death certificate and the affidavit into the bank, say these are the people who are entitled to this account.
Okay.
Over 75,000, it gets a little more complicated.
Over 75,000, all of a sudden you're talking to probate.
Interesting.
And quite frankly, it depends upon the bank's rules as well. Some banks make it more difficult to make that collection than others.
Let me just ask you one question real quick, Ken. I always like to ask kind of the unique questions, but we have had some people, how should I say this? I've heard about people going online. You know, you can do your online wills and save yourself a lot of money. You don't have to see an attorney. And we hear a little bit about that too when it comes to funeral homes. They say, like, you know, let's just call so and so. We'll have Mom cremated in Arizona, and we'll just come up and handle the funeral here ourselves, and it can open up a big can of worms. But I know how you feel about this. But tell me a little bit about your thoughts about do-it-yourself wills.
Well, I don't do my own dental work, if that's a start to this conversation.
Right.
And I teach a class in adult ed, and invariably I'll get that question, well, can't I get this offline? Can I get the form offline? Can I do it myself? My normal response to that is you can get virtually anything you want online. As a matter of fact, you can get things you don't want to see online. And so if you feel that you have to do that, go ahead and do it. Many years ago, there was an oil company or automotive company that created automotive filters called Fram Oil, and their commercial was pay me now or pay me later. And oftentimes when the do-it-yourselfers do some of these things that you're talking about, they may mess things up, and then it costs a lot more to go back and unravel the mistakes that were made that shouldn't have had to occur in the first place.
That's right. And of course, we've all heard stories about people that just sketch it on a napkin. And, I've got this Jimmy gets the cabin, and Tommy gets the boat, and Fred gets whatever. So I bet you've had to really sort out a lot of messes.
Yes. In short answer, yes. And it's incredible how people can get themselves into messes that they really didn't intend to get themselves into. And just knowing the difference between joint tenancy and tenancy in common and keeping property in your own name alone, so it's probate property or transfer on death, most people don't know those terms.
Exactly.
Most people don't know the effect of those things. And when it comes to real estate, there are certain standards above and beyond the statutes that have to be met in order to make that title marketable. And so there are traps out there. They're not necessarily by design, but there are traps that people can fall into, and they are very expensive to get out of.
So going to the real estate portion, and going back to my question about my wife and I, and saying that half of the home would be a probate triggered event for myself.
If you did not specify joint tenancy.
Joint tenancy. So let's say the listeners out there want to do that. What do they need to do?
Number one, I'd take a look at the deed to the home. The deed that you received the day that you bought the house, which is probably in papers that you haven't seen for 5, 10, 15, or 20 years. Take a look at that and see if it specifies joint tenancy or not. And take it to your local lawyer, or take it to one of the title companies and say, what do I have here? Is this joint tenancy? What exactly do I have in terms of my ownership rights? And you'll normally get those questions answered.
Okay.
It's funny. One of the things on my checklist, I ask people to either bring in a copy of their deed or bring in a copy of the abstract to their home. It's amazing how many people do not know where their abstract is located.
Absolutely.
That's true. And they got to call the title company to get a copy of it.
That's exactly right. And in Minnesota a couple of years ago, a law was passed that says that the lender can no longer just keep your abstract, because they did that as a matter of practice. So if you went through a mortgage foreclosure or whatever, they had the abstract and you didn't. So now they have to give you the option of keeping it yourself.
Well, I got a couple friends that wanted to put their home in their daughter's name. And I kind of expressed some thoughts about why they shouldn't do that. Maybe you can explain to the listeners on why it isn't just, you got a responsible child. Your responsible child is married. She has her own family. But why, as a married couple, you don't want to just put the house in your child's name?
That sounds like just a wonderful way to accomplish the eventual transfer of your title. But, things happen in life. Life is a 4-letter word. So she can die before you do. She can have a medical emergency that uses up all of her cash. There can be creditors out there that want to get that home, and they could get it under those circumstances. So before you make that transfer, and she may be responsible, she might be the best daughter you've ever had, but divorces happen, bankruptcies happen, medical emergencies happen, and so be careful of making that kind of a transfer.
Yeah, that could turn into an asset to her in the event of an unfortunate circumstance.
Exactly.
Yeah.
And she could... So let's say she dies before you do, the house is in her name, she's married to a guy that never really did care for you people, and so all of a sudden you're negotiating with him as to whether or not you can live there.
That's good information. We got about 10 minutes left, and I'm going to turn it back over to Tom. If we were on YouTube, we'd have a live chat, and I'd be able to look at the live chat and ask you more questions. Yes, but
then people would see all of us.
Well, and we might have Ken Norman back on our podcast, simply because if we hear from those that are listening that want to have him on and ask certain questions, we'd be happy to do that. We'd be happy to ask Ken to come and join us again. But just want to thank everybody for being here today, and thanks for giving us the opportunity to ask you these questions. And I'm going to turn it back over to Tom.
Well, thanks, Sean. One thing I have found in my number of years in funeral business is, in my personal affairs, it's just common sense. You just got to stay on top of things. We've had families come in with plenty of assets, and Dad has this life insurance policy to pay for his funeral, and Mom's the beneficiary, but she passed away 5 years ago. And it can be a real rat's nest, a real snare. And so that just, again, everybody just needs to know, you just can't assume these things. You got to stay on top of it.
It's amazing how many people don't even know who the beneficiaries are under their pension plan, their IRAs, their various and sundry accounts that they have. And you shouldn't go through life that way. At the very least, check with the people that are in control of your funds to say, okay, how are my assets titled?
Right.
Are they payable on death? Do I have beneficiaries? Do I have contingent beneficiaries?
And one can that we do not want to open is talking about blended families. That can be a whole another episode.
In your business, obviously, you've seen about all there is to see with blended families in terms of the reactions at the time of death. They can be very troublesome in the probate setting. They really can be. And so from that standpoint, good pre-planning fits us both.
Yep. Well, as we wind down, Ken, again, just a reminder for our listeners, Ken will be speaking at our seminar, and I'll talk about that again in just a moment. I can't reiterate that enough, but based on your experience, what else little tidbit do you think people should know that you'd like to get across before we sign off for the day here?
Well, the main thing is that people should be aware of where their important documents are. They should be aware of what their intentions are, and do those documents reflect what you want to happen under the circumstances? Mm-hmm. If you don't have that power of attorney, you get in the hospital, you may have to have a conservatorship, which is a court proceeding. If you get in the hospital and nobody knows what to do in terms of your care, you may have to have a guardianship, which again is a court proceeding that gets to be very expensive. The documents that we talked about, the tools that we talked about, are relatively inexpensive, and they can simplify the process for everybody involved.
Right. Just as one of the phrases we use in the pre-planning is have that conversation. Just talk about it. Don't just assume it's going to pan out.
Oh, exactly. And a lot of times you'll talk with people who don't want to tell their children anything, or their children will say, "Mom and Dad, have you guys talked about a will?" And they'll look at them and say, "What? Something that I don't know." And those of the Scandinavian descent are probably the most stoic in this area, and they're probably the most reticent to talk to their children about such things.
And if you bring these things up, they might think you've got your eye on the cabin or something like that. Have you talked about what you're going to do with the lake home? Why do you want it?
Exactly.
Something like that. All right.
But at the same time, like I said earlier, all of these documents are a matter of communication with the people who are making decisions on your behalf.
Absolutely. Well, we will wind down here and thank Ken very much for coming and being our guest today, and Sean co-hosting again today as well too. But one last time, I just want to remind all these listeners, we're going to drop this episode a little bit early since our seminar conference is going to be Tuesday, October 7th at the Courtyard by Marriott in Moorhead. And we're going to have a 2 p.m. session and a 6:30 p.m. session. They are free. Ken has been very quick to let people know that this is all free information from an attorney. So come on over.
This is the cheapest you'll ever have an attorney take advantage.
That's right. And we have cookies. Good cookies, I might add. But Ken is going to be speaking. Dave Hutchison from Northern Family is going to be talking a little bit about Medicaid also and the 5-year look-back period that we've been talking about briefly. Kurt Cannon and Jennifer Conklin from the Clay County Veteran Service Office will be there talking about the multitude of veterans benefits. I'm not a veteran, but we come away from these conferences with the veterans' spouses or kids saying, I never knew that. Or even the veterans will say that I can get a hearing aid, I can get a refrigerator. Just the benefits that people don't know about are incredible. And of course, I'll be there speaking a little bit about advanced planning from a personal standpoint. And I can say from experience, both of my folks had their advanced planning taken care of. And even though I've been in this profession for over 40 plus years, just knowing that they did it was a tremendous relief. So I will leave it at that. We'll have Ken's contact information on the notes on the podcast at the bottom. Our phone numbers, of course. We'll also have this conference flyer on the Corsmo Facebook page here in a couple of days. So we look forward to seeing you. So once again, folks, thank you for tuning in to More Than a Funeral, Voices of the Red River Valley. We look forward to next month's episode. Have a great day. You have been listening to More Than a Funeral, Voices of the Red River Valley. and I have been your host, Tom Pence, and I'm one of the funeral directors at Corsmo Funeral and Cremation Service here in Moorhead, Minnesota. The word service has been an intentional part of our name for over 66 years, and we pride ourselves on attention to detail and personal service. Personally, my responsibilities revolve around the advanced planning aspect of our profession, and I enjoy visiting with people as we discuss the many possibilities of a memorable celebration service that will eventually honor a life according to their wishes. And from a practical standpoint, which is getting so very important these days, I help families plan ahead so that the family left behind will not be burdened with a large financial responsibility, therefore allowing them to spend time with their family, remembering their loved one, not having to worry about how to handle the expenses. Asset protection is also a very real issue these days, as many care facilities can cost several $1,000s a month, depending upon the level of care. Corsmo can provide simple and effective ways of protecting those assets, and I welcome the opportunity to visit with you about that. If you enjoyed this podcast and found some value in it, we greatly appreciate your sharing with a friend. And if you have a moment, text somebody right now. Encourage them to give a listen and perhaps follow the podcast personally. We anticipate publishing a new episode on the first day of each month, so check back for interesting guests and topics. And of course, we also welcome your suggestions for future guests and topics of interest as well. So thank you for listening. And if you want more information and actually want some free estimates or just have questions, contact any of the directors at Corsmo Funeral and Cremation Service. Our phone number is 218-233-1533, and our web address is corsmofuneralservice.com. Thanks again for listening, and from all of us at Corsmo, have a great day.